lecture, let us discuss part 1 of the Constitution of India, Union and its territory. And we shall be discussing 4 articles, Articles 1 to 4. But first up, 2014, we had 28 states in India and we had 7 union territories. But in 2014, Andhra Pradesh was reorganized. Andhra Pradesh was bifurcated into Andhra Pradesh and Telangana. A new state, Telangana, was carved out from Andhra Pradesh. That means post 2014, we had 29 states and 7 union territories. Then on August 6, 2019, Jammu and Kashmir was also reorganized. The then state was downgraded because Jammu and Kashmir had a special status. The state of Jammu and Kashmir was downgraded to that of a union territory, and Jammu and Kashmir was reorganized and bifurcated into union territories. 2 union territories, Union Territory of Jammu and Kashmir and the Union Territory of Ladakh. But this Jammu and Kashmir reorganization bill came into effect, entered into force on October 31, 2019. So the parliament decided, the government decided that we will enact, that we will enforce, that we will implement this Jammu and Kashmir Reorganization Act on 31st October 2019. But why? October 31 is the birth anniversary of Sardar Vallabhbhai Patel, the Iron Man of India. And we also call him the Man of Unity. Why? There were close to 562 princely states when British was governing India. And now majority of these princely states were to be merged with the Union of India. And there was one man responsible for that, Sardar Vallabhbhai Patel. He was pivotal, he was instrumental in merging majority of these 562 princely states with the Union of India. That is why we call him the Man of Unity as well. 31st October is the birth anniversary of Sardar Vallabhbhai Patel, the Man of Unity. So if Jammu and Kashmir was downgraded to that of Union territories and it was completely merged with the Union of India, the government decided, the government thought that let's coincide this with the birth anniversary of Sardar Vallabhbhai Patel. So this Jammu and Kashmir Reorganization Bill, which bifurcated Jammu and Kashmir into 2 union territories, it came into effect on 31st October 2019. That means on this date, we had 28 states again, but also 9 union territories. So 28 states and 9 union territories. But something else happened. 26th January 2020, what we celebrate as the Republic Day. On 26th January 2020, 2 union territories were merged. Daman and Diu was one union territory. Dadra and Nagar Haveli was another union territory. Effective 26th January 2020, both these union territories were merged together. And now we have this common union territory which is named as Daman and Diu, Dadra and Nagar Haveli. So that means if we look at the territory of India right now, we have 28 states and we have 8 union territories. 2 additional union territories, Jammu and Kashmir and Ladakh. But 2 union territories were also merged, Dadra and Nagar Haveli and Daman and Diu. So right now, we have 28 states and 8 union territories. Now let's discuss part 1 of the Constitution of India, Union and its territory, and we shall be discussing 4 articles, Articles 1 to Article 4. But first up, Article 1, the name and territory of the Union. If you look at Article 1, Clause 1, it says, India, that is Bharat, shall be a union of states. There are 2 phrases very important for you to understand. India, that is Bharat, and union of states. First, let's look at what is this India, that is Bharat, which basically means that we have dual name for this country. The name of this country is India as well as Bharat. That is what we call India, that is Bharat. But why both these names? When Constituent Assembly was set up, and what is this Constituent Assembly? A body which is tasked to draft the Constitution of India. That means once India was given independence, now this independent country needs to have its own constitution because not be run on the basis of the laws passed by the British Parliament. Now we are independent. So then in 1946, the British government decided that let's give power to the people of India. Let them frame their own constitution. And that is how Cabinet Mission was set up. That is how in 1946, power was given to the people of this country that you can frame your own constitution. And on 9th of December 1946, this Constituent Assembly met for the first time. This Constituent Assembly had to decide what are going to be the rules on the basis of which this country will be run. But the question also was, what should be the name of this country? Some people said that we should stick to this name India. Why? Because we are known world over by this name. We are known throughout the world as India, so let's stick to this name India. But others said, no, India is the name given by the colonial empire. India is an alien name. India is a foreign name. We should stick to our traditional name, which is Bharat. Some people said, no, why call it India? Why call it Bharat? Let's call it Bharatvarsh. Some people said, no, we should call it Hindustan. Some people said, no, we should call it Jambudvip, the land of the Jambu tree, because that is how we were known in the ancient India. Some people said, who were very close, very sympathetic to Soviet Union, because they believed in the socialist ideology, the communist ideology, they said, let's imitate USSR, Union of Soviet Socialist Republics. So we should call this country as Union of Sovereign States of India. So there was a confusion. There was a lot of debate. There was a lot of discussion and deliberation on the nomenclature for this country, the name of this country. Some said, let's stick to India. Some said, no, we need a traditional name, Bharat. Some said, no, let's call it Hindustan. Some said, no, let's call it the Union of Sovereign Socialist States of India on the lines of USSR. And ultimately, this confusion, this problem, this controversy was settled. Two names were given, reflecting the modernity as well as the tradition. So that is why the name of this country, we have dual name. India, that is Bharat. So both these are the names for this country. India, that is Bharat. So this controversy was settled when Constitution was given to us, when the Constitution was enacted on 26 January 1950. But even then, some people were not satisfied. In 2016, an activist from Maharashtra, he approached the Supreme Court and said, "Dear Supreme Court, I am filing a public interest litigation." What is this PIL? We will discuss in detail when we will talk about judiciary. But this individual from Maharashtra, he filed a public interest litigation in the Supreme Court and asked the Supreme Court, "Dear Supreme Court, please issue a directive to the Parliament. Please ask Parliament to change the name of this country. We should stick to the name Bharat, not India, because India represents the colonial aspirations. We should stick to the traditional name, which is Bharat." Ultimately, the Supreme Court rejected this public interest litigation. The then Chief Justice of India said, "Don't come to us with these frivolous, emotional issues. Use the power of public interest litigation to fight corruption in the society, to fight the climate change in this country. So we are rejecting this public interest litigation. That means once and for all, the dust is settled, the matter is resolved. We have dual name for this country, India, that is Bharat." But some people were still not satisfied. May 2020, an individual named Nama, he approached the Supreme Court and filed another public interest litigation. That, "Dear Supreme Court, what you have to do, issue an order. Issue an order to the Parliament that please have a constitutional amendment. Let's amend the constitution and delete this word India, because India does not represent the tradition of this country. So we should call this country Bharat and not India." But in June 2020, the Supreme Court decided to postpone the hearing on this public interest litigation. So now we are almost certain again. We have dual name for this country, India, that is Bharat, reflecting the glorious mix of modernity as well as the tradition. So when we look at union and its territory, part 1 of the Constitution of India, I told you we have to discuss articles 1 to 4. But before that, how many states do we have? 28. How many union territories do we have? 8. But why do we have union territories in the first place? That I'm going to discuss when we will talk about the chapter Union Territories. So right now we are only going to talk about union and its territory. So basically, the territory of India consists of what? We can either have states, or we can have union territories, or we can have something else that I'm going to tell you slightly later. But we are not going to discuss the rationale behind why we have union territories. That we will discuss slightly later. But right now, what are we talking about? We are talking about Article 1. Article 1, Clause 1. India, that is Bharat, shall be a union of states. Two phrases are important. Number one, India, that is Bharat, which means that we have dual name for this country, India as well as Bharat. Second is, shall be a union of states. This is where there is a controversy. What is the controversy? When we say union of states, does that mean India is a unitary constitution? If India is a federal constitution, Article 1 should have mentioned India, that is Bharat, shall be a federation of states. Because if you are saying India, that is Bharat, shall be a union of states, that means the Constitution of India is itself accepting that we are a unitary constitution. This question was posed to Dr. B.R. Ambedkar, the architect of our constitution, the chairman of the drafting committee of the Constitution of India. He was asked, if our constitution is federal in character, federal in nature, then why are you using the phrase union of states? Instead, you should have said India, that is Bharat, shall be a federation of states. But you're saying India, that is Bharat, shall be a union of states. Should we assume that Indian constitution is unitary in character? Dr. B.R. Ambedkar replied, and he said, no, Indian constitution is federal in character. But I have used the phrase union of states for two reasons. What are these two reasons? Number one, India is not the result of an agreement between states. He was asked to explain, what do you mean when you say India is not the result of an agreement between states? He said India was already there. So India as a political entity was not created because the states got together and created India. India was already there. Yes, there were these princely states, and they decided to give up their sovereignty and merge with the Union of India, accede to the Union of India. That is why India as a political entity was already there. So we can't say that India is the result of an agreement between states, and this agreement created India. India was already there. That is why we call it a union of states. We don't call it a federation of states. But he was asked to explain more. He said, look at United States of America. If you look at United States of America, which is in Northern America, there were 13 British colonies. Primarily, these 13 areas were under the control of the British Empire, the British colonial empire. Then the people of these 13 colonies, they decided to revolt. They decided to launch a war for independence. That is what we call America's War for Independence. And ultimately, the British rule was overthrown, and these 13 British colonies, they became sovereign, they became independent. But then what happened? All these 13 British colonies who gained independence, who gained sovereignty, they decided to come together. They wanted, let's now create a United States of America. That means United States of America was not present before. This United States of America was created when these 13 British colonies, they liberated themselves. They came out of colonialism, and ultimately they decided to come together and create United States of America. That is why United States of America, we call it a federation of states, because this United States of America has been created because of an agreement between these 13 British colonies. But that's not the case with India. India as a political entity was already there. Now these princely states were given an option. Either you can join India or you can join Pakistan. And thanks to Sardar Vallabhbhai Patel, majority of these princely states, they decided to be part of India. They decided to accede. They decided to merge with the Union of India. That is why we can't call it a federation of states, because India is not the result of an agreement between the states. That's one reason. Second reason why B.R. Ambedkar said, I have not used the term federation of states, but instead I have used the term union of states, because no state has the right to secede from the Union of India. Till about 1970s, there was a perception that when we call a constitution as federal constitution, when we call a political entity as a federation, one part of this federation may at any point in time come out of this federation. That means, let's say, for example, there is one political entity which has been created because of the agreement between various constituent units, because of the agreement of various states. One state may come out of this agreement and declare independence, declare sovereignty, take its sovereignty back. That means one state can secede from the federation. But this is something that we cannot give to any Indian state. When we say we are calling India that is Bharat, shall be a union of states, that means no unit of this union, no state has the power, has the authority, has the option of coming out of the Union of India. That means there is no provision for secession. That is why B.R. Ambedkar said, I have used the phrase union of states. That means when we look at Article 1, Clause 1, India, that is Bharat, shall be a union of states. India, that is Bharat, that means dual name for this country. India as well as Bharat shall be a union of states. But does that mean Indian constitution is unitary in character? Because Article 1 of the Constitution of India says, India, that is Bharat, shall be a union of states. But B.R. Ambedkar said, no, we are a federal constitution. But I'm using the phrase union of states because of two reasons. Number one, India is not the result of an agreement between states. And number two, no state has the right, has the option, has the power to come out of the Union of India, to secede from the Union of India. That is what we call India, that is Bharat, shall be a union of states. That is Article 1, Clause 1. Let's look at Article 1, Clause 2. The states and territories thereof shall be specified in the first schedule. Now for this, what we need to understand. Number one, what is a schedule? Number two, what is the reason to have a schedule? But first up, when we look at Article 1, Clause 2, it says the states and territories thereof shall be specified in first schedule. So what is the schedule? In this schedule, what will be mentioned? The names of the 28 states that we have, the 8 union territories that we have. That means if we look at the first schedule of the Constitution of India, it talks about, it details the names of the states that we have, the names of the territories that we have. That is why we have first schedule. But the point is, what is a schedule and what is the need to have a schedule in the Constitution of India? Originally, in 1950, when Constitution was enacted, we had 8 schedules of the Constitution. Over a period of time, 4 more schedules were added to the Constitution of India. So right now, we have 12 schedules of Indian Constitution. But what is a schedule? Schedule is basically an explanatory memorandum of an article. What does that mean? A schedule is an explanatory memorandum of an article. That means if there is an article in the Constitution of India which requires more explanation, for that what we do? We add a schedule at the end of the Constitution. But what is the purpose? Purpose is basically cosmetic. And what do we mean by a cosmetic requirement for having a schedule in the Constitution? Let's say, for example, instead of this phrase, the states and territories thereof shall be specified in the first schedule. Instead of this, we could also have mentioned the states and territories thereof are specified below. So below this article, we would have a list of 28 states and 8 union territories. But constitution makers thought if there is an article which requires more explanation, for that we should add a schedule at the end of the Constitution. Otherwise, this article would become very bulky. So if without a schedule, if there was no schedule, Article 1, Clause 2 would have been like this. The names of the states and territories are mentioned below. 28 states, 8 union territories. The entire article would be very bulky. So maybe constitution makers at that point in time realized that lean is in. So if we want to make our constitution, the articles in the constitution as short as possible, as precise as possible, if an article requires more explanation, don't add it to the text of the Constitution. Instead, add a schedule at the end of the Constitution. I'll give you one more example. And this is something that we will discuss in detail later on. But for you to understand what is a schedule, what is the need to have a schedule, let me give you one example. One example is Article 246 of the Constitution of India. What is Article 246? It talks about distribution of powers. That means some powers are given to the center, the parliament, some powers are given to the states, some powers are given jointly to both center as well as state. That is why we call a union list, a state list, a concurrent list. That means on banking, on insurance, on currency, on foreign affairs, on defense, who has the power? Who has the lone power to make laws? Parliament. So all these items are mentioned under the union list. But states also have some powers. Law and order, land, police, agriculture, gambling. These powers are given to the states. But there are some powers which are given to both center as well as states. State legislatures as well as the parliament. For example, criminal procedure code, civil procedure code, marriage, divorce. When we look at Article 246, if all these subjects would have been mentioned under Article 246, then this Article 246 would be very bulky. So to prevent the situation, to ensure lean is in, what happened? A schedule was added at the end of the Constitution. And this distribution of powers is mentioned under 7th schedule of the Constitution of India. Long story short, Article 1, Clause 2, the names of the states and territories thereof shall be specified in first schedule. So what is first schedule? First schedule details the names of 28 states and 8 union territories that we have. But what is a schedule? Schedule is basically an explanatory memorandum of an article. If an article requires more explanation, don't add it to the text of the Constitution, add a schedule at the end of the Constitution. Why? Cosmetic reason. So that this article would not be bulky, so that if an article requires more explanation, add this explanation at the end of the Constitution by adding a schedule. That is what we call a schedule. And what is first schedule? It mentions the names of 28 states and 8 union territories that we have. And then Article 1, Clause 3. The territory of India shall comprise of, number 1. That means when we look at Article 1, Part 1 of the Constitution of India, talks about 4 articles. 1, 2, 3, 4. What is Part 1? Union and its territory. That means if the union is India, what is the territory that is part of India? That is under the control of India. That is part of India. For that, there has to be some explanation, and that explanation is provided by Article 1. And Article 1, Clause 3 talks about what types of territories can we have. So Article 1, Clause 3 tells us that either we can have states, or we can have union territories, or we can have acquired territories. That means, let's say, for example, if this Clause C was not present, that means the territory of India would have been fixed forever. We could neither gift a part of our territory to another country, nor we could have acquired a part of a territory of another country. That means the territory of India would have been fixed forever. To prevent that situation from happening, the constitution makers thought that let's have another category in place. The territory of India will consist of either we can have states, the 28 states that we have, or we can have union territories, the 8 union territories that we have, or we can have acquired territories. And how can I give you an example of an acquired territory? One such example is the French settlement of Pondicherry, or now we call it Puducherry. Pondicherry basically was a French colony. But then in 1954, there was an agreement between the government of India and the government of France. And it was because of that agreement that Pondicherry became part of India. But it was not originally part of India. It was acquired. India acquired the territory of Pondicherry from France. That is why we call it an acquired territory. And then in 1962-63, Pondicherry became the Union Territory of India. Because till 1962, Pondicherry was administered by the government of India as an acquired territory. Why? There is a difference between signing an agreement and ratifying an agreement. What is the difference? Let's say, for example, in 1954, there was an agreement signed between the two governments, Government of India and the Government of France. What was the agreement? Both governments agreed that this territory, Pondicherry, should be acquired by India. this territory should be legally acquired by India from France. There was government to government agreement. But this agreement, which was signed between the government of India and the government of France, it had to be ratified by the French Parliament. French Parliament took some time, and French Parliament ratified this agreement in the year 1962. That means this agreement was signed in 1954, but it was only the signing of an agreement, because only the governments of both the countries, they accepted this agreement. But this agreement needs to be ratified. And how can we ratify it? We can ratify it by parliamentary approval. This parliamentary approval was given by the French Parliament in the year 1962, and that is how Pondicherry legally became the part of India. But from 1954, when the agreement was signed, till 1962, when the ratification was done by the French Parliament, in these years altogether, French settlement of Pondicherry was administered by the government of India as an acquired territory. That means either we can have states, or we can have union territories, or we can have acquired territories. Tomorrow, we can acquire a part of another country and make it part of India. But ultimately, there is a difference between signing an agreement and ratifying an agreement. Agreement is signed by governments, but agreements are ratified by the respective legislatures, respective parliaments. And it was only in 1962 when the French Parliament ratified the treaty, ratified the agreement, that Pondicherry became a legal part of India and it was given the status of a union territory. This completes our Article 1 of the Constitution of India. So recap, Article 1, Clause 1, India, that is Bharat, shall be a union of states. We have dual name for this country, India as well as Bharat. Union of states does not mean that Indian constitution is unitary. It means Indian constitution is federal, but for two reasons, we have used the term or the phrase union of states instead of federation of states. The names of the states and territories shall be mentioned where it shall be specified in the first schedule. What is a schedule? If an article requires more explanation, add a schedule at the end of the constitution. So schedule is basically an explanatory memorandum of an article, and it is only for cosmetic measures. Then, if you look at the territory of India, either we can have states, or we can have union territories, or we can have acquired territories. And one such example of an acquired territory is the French settlement of Pondicherry. Now let's look at Article 2 of the Constitution of India. Parliament may, by law. What Parliament can do? It can enact a law. And through this law, what Parliament can do? It can admit into or establish new states on such terms and condition as it thinks fit. Now let's understand Article 2. What Article 2 says? That Parliament may, by law. What Parliament can do? It can enact a law, it can pass a law. And through this law, Parliament can admit into union a state, Parliament can establish a new state, and that too on such terms and conditions as it thinks fit. The best way to make you understand Article 2 is if we cite the case of Sikkim. Sikkim was originally not part of India. When in 1947 India became independent, the country was partitioned into India and Pakistan. Sikkim was not part of India. Sikkim was ruled by a hereditary monarch, and that institution of monarchy was what we call Chogyal. So Sikkim was basically a princely state, was basically a kingdom. It was ruled by a monarch, and the institution of monarchy was called Chogyal. But soon Sikkim realized that I have a bigger neighbor, India, and I need protection from other countries. This is where Sikkim and India entered into an agreement, and because of this agreement, Sikkim became a protectorate of India. And what is this protectorate? In international law, protectorate is an entity which is protected by a stronger state. That means there is a stronger state which protects this slightly weaker state, and this weaker state is granted diplomatic protection, military protection by the stronger state. That is what we call protectorate. That means a stronger state, India, is giving protection, diplomatic protection, military protection to Sikkim. And this is how this relationship worked. And this relationship continued. But then came the spring of 1973. There were protests in Sikkim. And the people in Sikkim, they wanted to be part of India. They did not want to be governed by this hereditary institution called Chogyal. They wanted to be part of India. Some people say that Indian Intelligence Agency, the external intelligence agency that we have, RAW, Research and Analysis Wing, RAW, it played a very important pivotal role in molding the public opinion in Sikkim so that Sikkim, which is strategically located, also becomes part of India. And then there were protests in Sikkim, the spring of 1973, where large-scale protests broke out and the people in Sikkim, they wanted to be part of India. Ultimately, there was a compromise. And there were three parties to this compromise: Chogyal, the people of Sikkim, and the government of India. And ultimately, government of India brokered peace, and government of India asked the institution of monarchy in Sikkim, let's organize elections. Elections were organized, and a pro-India political party in Sikkim, Sikkimese Congress, won the election and ultimately captured power in Sikkim. But when this government in Sikkim was formed by a political party which is sympathetic to India, by a political party which favors merger with India, this government, what it did in Sikkim, the parliament in Sikkim passed a law, and because of this law, the powers of Chogyal were restricted. Chogyal now was converted into a nominal constitutional head. That means prior to 1974, prior to the spring of 1973, all the powers were concentrated in the king. All the powers were concentrated in the hands of Chogyal. But now once the elections were held, a pro-India political party won the election and the parliament of Sikkim passed a law, and because of this law, the powers of Chogyal were clipped and Chogyal became a nominal constitutional head of Sikkim. That means basically a nominal head, a titular head with no powers, because real powers were vested with the Parliament of Sikkim or the Assembly of Sikkim, Legislative Assembly of Sikkim. That means the Chogyal of Sikkim became just like a British queen. Only a ceremonial head, only a nominal constitutional head with no real powers, because the real powers were vested with the people of Sikkim. Ultimately, what happened? Chogyal sensed conspiracy on behalf of India. And Chogyal went to many countries and asked the support of these countries because he alleged that India is interfering in the internal affairs of his kingdom. And ultimately, he sought international help. This is where Parliament of India enacted another law. Constitution was amended. 35th Constitutional Amendment Act in 1974. Sikkim was admitted into India as an associate state. What happens? Parliament may by law admit into or establish new states on such terms and conditions as it thinks fit. To explain this, we need to look at the condition of Sikkim. Sikkim was under a hereditary monarch, but now because of the protest, ultimately there were elections in Sikkim and a pro-India political party won the election. The powers of Chogyal were clipped. Chogyal became a nominal constitutional head. Chogyal is sensing conspiracy. Chogyal is seeking international help. Government of India comes into the picture. Parliament of India gets its act together, amends the constitution. 35th Constitutional Amendment Act in 1974, and Article 2 capital A was added. And because of this Article 2 capital A, Sikkim became an associate state of India. But then what's the controversy? The controversy is, let's go back to Article 1. Article 1, Clause 3, what does it talk about? It says that India either can have states, or India can have union territories, or India can have acquired territories. There is no mention of this term called associate state. This is where the opposition, the then opposition, criticized Mrs. Indira Gandhi. Mrs. Indira Gandhi was then the Prime Minister. She was heavily criticized because it was alleged that she has violated the Constitution when Constitution only talks about states or union territories or acquired territories. There is no mention of any term called associate state. So how can the Parliament of India admit Sikkim as an associate state, not as a regular state? But that was the diplomacy of Mrs. Indira Gandhi. She could not have admitted Sikkim as a full-fledged Indian state because the legitimate ruler, the Chogyal, is not in agreement. Second, it could not have been a union territory. Third, if it was admitted as an acquired territory, but you can't simply acquire a territory, there has to be an agreement between the two parties. And ultimately, the signal it would have sent to the world that India has acquired Sikkim, that would not have been diplomatically prudent. So what she did, invented a novelty, an innovation, and she used Article 2 of the Constitution of India. Parliament may, by law. What Parliament can do? It can enact a law. What was the law? 35th Constitutional Amendment Act 1974. And through this law, it admitted a state, Sikkim, on such terms and conditions as it thinks fit. And the Parliament thought it fit to admit Sikkim as an associate state. But when Sikkim was admitted as an associate state, but then what happened? When Sikkim was admitted into the Union of India as an associate state, Chogyal was somebody who could not remain silent. And ultimately, he was still seeking international help. Then what happened? There was a referendum in Sikkim. People in Sikkim, they were asked, who are you going to vote for? Do you want to completely merge with the Union of India? Or do you want to remain independent and part of this hereditary monarchical structure? And more than 99% people in Sikkim, they voted overwhelmingly in favor of India. And then what happened? Just a year later, again Constitution was amended. 36th Constitutional Amendment Act of 1975. Article 2 capital A was deleted and Sikkim became just like any other Indian state. That means this innovation, this novelty that was introduced in the year 1974, it lasted only a year. Because in 1975, just a year later, again the constitution was amended and this Article 2 capital A, which gave Sikkim the status of an associate state, that Article 2 capital A was deleted and Sikkim became just like any other Indian state. But long story short, look at the spread of Article 2. It says Parliament may by law admit into union or establish new states on such terms and conditions as it thinks fit. And the example for that is Sikkim. The distance, the journey of Sikkim from a protectorate to an associate state and then as a full-fledged state of Union of India. That is what Article 2 of the Indian Constitution is all about. Now let's look at Article 3 of the Constitution of India. What Article 3 talks about? Parliament may by law. What Parliament can do? It can pass a law. And through this law, what Parliament can do? It can form a state. How? A state can be bifurcated, trifurcated, separated to create few more states. For example, Uttar Pradesh in the year 2000 was bifurcated, or a part of Uttar Pradesh was separated, and that separated part became Uttarakhand. First Uttaranchal, then Uttarakhand. Similarly, Bihar, the same year, 2000. One part of Bihar, Jharkhand, was carved out from Bihar. In a similar fashion, the same year 2000, Madhya Pradesh also, one part of Madhya Pradesh was carved out from it and it became Chhattisgarh. 2014, Andhra Pradesh was bifurcated into Andhra and Telangana. That means what Parliament can do? Parliament can pass a law, and through this law, what Parliament can do? It can separate a part from one state and make this part another state. Merge two or more states together. That is the power which is available to the Parliament. What Parliament can also do? It can increase the area of any state. It can decrease the area of any state. It can change the name of any state. It can alter the boundaries of any state. That is the power which is available to the Parliament under Article 3 of the Constitution of India. But this is where two important concepts are required. Number one, if you look at United States of America, we call United States of America an indestructible union of indestructible states. The Union, United States of America, will remain united. And all these 50 states that are part of United States of America, they will remain 50. That means in United States of America, the Constitution does not talk about that you can divide a state. The Constitution says that United States of America is an indestructible union of indestructible states. Without the consent from the states, you cannot destroy that state. You cannot split that state. But when we look at India, we are an indestructible union, but of destructible states. Union of India will remain Union of India. But today we can have 28 states. A few months ago, we had 29 states. Tomorrow we can have 30 states, or we can have 35 states. That means states can be bifurcated. States can be trifurcated. States can be merged together. That means India is an indestructible union, but of destructible states. That's the concept number one. But concept number two, very important. When we say India is a federal constitution, but even then, there are some features in Indian constitution which gives a unitary bias to our constitution. If you look at these features, we say that although Indian constitution is federal, but there are some features in the Indian constitution which are biased in favor of center, which are favoring the center, which are favoring the union. One such feature is Article 3 of the Constitution of India. That means states can be split, states can be merged, their names can be changed, but who has the power to do this? Parliament, not the states. Even without consulting the states can be bifurcated, the states can be trifurcated, the states can be downgraded. That is why we say this is one of the centralizing tendency of Indian federalism. India is a federal constitution. India is a federal polity, but there are some features which give a centralizing bias, a unitary bias to our constitution. And one such feature is Article 3 of the Constitution of India. But how can Parliament do all of this? Parliament has to follow a procedure. And what is that procedure? Let's look at that procedure. That procedure is something that we call a consultative process. What is a consultative process? Let's say, for example, I'll give you the example of 2014. That's how you can best understand Article 3. 2014, what happened? There was a demand that Andhra Pradesh should be bifurcated, Telangana be carved out from Andhra Pradesh. Why? Because the people of Telangana, they have been discriminated against by the coastal Andhra. I don't know whether that is true or not, because that's not my domain. But I can only say that this is what led to the creation of Telangana. There was an element of bias. There were allegations of favoring the state, favoring the coastal Andhra, the Rayalaseema region, and not favoring or discriminating the people of Telangana. And that is why there was this Telangana movement, and people in Telangana, they wanted a separate state for themselves. That means Andhra Pradesh should be bifurcated, Telangana should be carved out from Andhra Pradesh. But for that, who has the power to do this? Parliament under Article 3. But Parliament has to follow a process. And that is what we call a consultative process. What is this consultative process? Basically what happens, the Union Cabinet, Prime Minister, his cabinet ministers, they clear this proposal. They say, yes, now the time is ripe. Andhra Pradesh should be bifurcated into Andhra Pradesh and Telangana. And they pass a bill. That means Union Cabinet clears a bill. And this bill is what we call Andhra Pradesh Reorganization Bill. Andhra Pradesh should be reorganized. What is a bill? Bill is a proposal. What is the proposal of this bill? Andhra Pradesh should be reorganized. Reorganized into Andhra Pradesh and Telangana. Who cleared this bill? Union Cabinet, the central government. And now this bill should be presented first to the president. Normally what happens? When the bill is cleared by the cabinet, it is tabled in the parliament, both Lok Sabha and Rajya Sabha. When they pass this bill, then this bill is sent to the president. When president signs this bill becomes a law, this bill becomes an act, and this act enters into force. But so far as bill under Article 3 is concerned, when this bill is cleared by the Union Cabinet, this bill, before it can be tabled in the parliament, it's sent to the President of India. Dear President, can we please introduce this bill in the parliament? That means a bill under Article 3 cannot be introduced in the parliament without the consent, without the permission, without the approval of the President of India. That is very important for your prelims examination. Which means when this Andhra Pradesh reorganization bill was cleared by the Union Cabinet, before it could be introduced in the parliament, it was sent to the President. President was told, dear President, please give us the permission. We want to table this bill in the parliament. And we want Parliament to pass this bill so that this reorganization bill becomes a reorganization act so that Andhra Pradesh is bifurcated into Andhra Pradesh and Telangana. President said, no, wait. I have to follow a process. And that process is mentioned in the constitution itself. And what is that process? I will ask the legislative assembly of that state which is going to be affected by this bill. And which legislative assembly is going to be affected by this bill? Andhra Pradesh Legislative Assembly. So what I will do, before I can give you a permission so that you can table this bill, introduce this bill in the parliament, I want to seek the opinions of the Legislative Assembly of Andhra Pradesh. Then in a special aircraft, this Andhra Pradesh reorganization bill, it was sent to the Legislative Assembly of Andhra Pradesh. Andhra Pradesh Legislative Assembly discussed it and rejected it in toto. Andhra Pradesh reorganization bill should be rejected, said the Legislative Assembly of Andhra Pradesh. Andhra Pradesh Assembly said, in unanimity, by a unanimous decision, we are passing a resolution. We want a united Andhra Pradesh. We don't want bifurcation of Andhra Pradesh into Andhra Pradesh and Telangana. So we are rejecting this Andhra Pradesh reorganization bill of 2014. President said, so what? I know what your views are, what your standpoint is, but even then, I'm going to give my permission to the central government. You can introduce this bill in the parliament. That means it is only a consultative process. The president is only consulting the state. Whatever views are given by the state, that's not binding on the president of India. That means the president is following the constitution only for consultation. That means the constitution gives the power to the center. Center can reorganize the country. But yes, under Article 3, President has to follow a process, a consultative process. When this bill is sent by the Union Cabinet to the President, please give us your permission. We want to introduce this bill in the Parliament. President says, no. First, I want to refer this bill to the Legislative Assembly of that state, which is going to be affected by this bill. And I want to know what are the views of that Legislative Assembly. And ultimately, Legislative Assembly of Andhra Pradesh said, we reject this bill. President said, doesn't matter. Ultimately, this bill was tabled in the parliament. Both Lok Sabha as well as Rajya Sabha passed this Andhra Pradesh reorganization bill. The majority required is simple majority. That means majority of all the members present and voting. Ultimately, by simple majority, Andhra Pradesh reorganization bill was passed. Andhra Pradesh reorganization bill became Andhra Pradesh Reorganization Act. And ultimately, Andhra Pradesh was bifurcated into Andhra Pradesh and Telangana. That is why we say Article 3 represents the centralizing tendency of Indian federalism. Although our constitution is federal, but there are some features, there are some provisions which give a unitary bias to Indian constitution. And one such feature is Article 3, reorganization of the country. Even without the consent from the states, even without the concurrence of the states, the central parliament can reorganize this country. That is what Article 3 of the Constitution is all about. But now another example, and this is something you may be interested in. Jammu and Kashmir. Jammu and Kashmir, initially a princely state, then became part of India, but it was accorded a special status under Articles 370 of the Constitution of India and Article 35 capital A of the Constitution of India. Now Article 35 capital A disappeared. Article 370 is still part of the Constitution. It has not been deleted. It has not been abrogated. It's still part of the Constitution, but it has been deoperationalized. That means it is something which is not into force. But why it happened, how did it happen, that we are going to discuss when we will take up the chapter Jammu and Kashmir. Today we are only going to talk about how Jammu and Kashmir was reorganized. How Jammu and Kashmir, which was a state, how it was downgraded to that of a union territory, and how it was bifurcated into two union territories. Because that is something unprecedented, unusual, never happened in the history of independent India except Delhi. Because Delhi initially was a state till 1956, and then it was demoted to that of a union territory. Barring the exception of Delhi, we didn't witness a single case where a full-fledged state was downgraded to that of a union territory. Yes, we saw Goa, which was a union territory, it was upgraded to that of a state. Similarly, Arunachal Pradesh, Manipur, Mizoram, previously union territories, then were upgraded to that of full-fledged states. But after 1956, we never witnessed a case where a state was downgraded to that of a union territory. So how it happened for Jammu and Kashmir, that is something that we are going to discuss now. But how Article 370 was deoperationalized and what is this Article 370, that we will discuss in the chapter Jammu and Kashmir. When the Legislative Assembly elections were held to the state of Jammu and Kashmir in the year 2015, no political party was in a position to form the government. And ultimately, there was a coalition government. The PDP, the People's Democratic Party, and the BJP, the Bharatiya Janata Party. Ultimately, they ran the coalition for some time, and after that, BJP said divorce. The BJP withdrew support to the Mehbooba Mufti government, and ultimately the government collapsed. After that, the state was under the governor's rule. And governor's rule is the term that we used only and only for the state of Jammu and Kashmir. Because Jammu and Kashmir had its own constitution. And under that constitution, there should have been a governor's rule. If there is no popular government, if there is no democratically elected government, then there will be governor's rule for a period of 6 months. Once the 6-month period is over, then there will be president's rule under Article 356 in the state of Jammu and Kashmir. This I'm talking about 2017. So basically, when BJP withdrew support to the Mehbooba Mufti government, the government fell. No other political party was in a position to form the government. No other political party was in a position to come in coalition with another political party and form the government. Couldn't happen. The state was initially under governor's rule, under the constitution of Jammu and Kashmir. Now this constitution does not exist. But it was under governor's rule for 6 months and then under president's rule under Article 356 of the Constitution of India. So basically under Article 356, what happens? We'll discuss that when we will talk about emergency chapter, when we will talk about president's rule. But very briefly here, when there is president's rule in a state, which primarily means there is no council of ministers, there is no chief minister, which basically means who administers the state? Center. Who is the head of the center? President. That is why we call it president's rule. That means president is directly administering the state because the state has been placed under president's rule because there is no chief minister, there is no council of ministers. But chief minister, council of minister, they are part of the executive, right? But who is part of the legislature? There is no legislature because legislative assembly is dissolved. It happened when three political parties, they decided to come together. The National Conference, the Congress, and the PDP. They decided to come together and form the government. There was another party, People's Conference. It said that we have the support of the BJP and we are in a position to form the government. They also approached the governor that dear governor, give us the opportunity. We are in a position to form the government. Governor said there are two claimants. Two individuals are claiming that they have got the numbers. Ultimately, what governor did, he dissolved the legislative assembly. So now we don't have a legislative assembly in Jammu and Kashmir as well. I'm talking about 2017. So there is no chief minister, there is no executive, there is no legislature, legislative assembly has been dissolved. And in such a situation, when there is a president's rule, when we can't have a legislative assembly, who has the power to make laws for that state? That power is given to the parliament. This we will discuss in detail when we will talk about president's rule, but very briefly here. When there is no executive, president is the head of that state. When there is no legislature, parliament becomes the legislative assembly for the state of Jammu and Kashmir. So now in 2019, August 5, 2019, what happens? Who is the legislative assembly for the state of Jammu and Kashmir? Parliament of India. Who is the executive head of that state? President of India. Because the state is directly under the control of the center. The state is under the president's rule. So what happened? Mr. Amit Shah, the Home Minister of India, he approached the Rajya Sabha and said that now I want to introduce Jammu and Kashmir Reorganization Bill of 2019. What is this bill? Bill is a proposal. What is the proposal? Proposal is Jammu and Kashmir should be reorganized. The state of Jammu and Kashmir should be downgraded to that of a union territory. And union territory also should be split. We should have two union territories. Union territory of Jammu and Kashmir, union territory of Ladakh. That's my proposal. I need parliamentary approval for these proposals so that Jammu and Kashmir reorganization bill becomes an act. This act is entered into force. But then people asked, for Jammu and Kashmir reorganization bill to be passed, you require the views of the legislative assembly of that state. Since there is no legislative assembly, that means you can't seek the views. That means you can't introduce Jammu and Kashmir reorganization bill in the parliament. The argument of the government was, who has the power under Article 3? Parliament. What parliament can do? It can separate a state. It can bifurcate a state. It can separate a part of that territory and make this territory a separate state or a separate union territory, anything. That's the power which is available to the parliament. So we are exercising our power. What the government said? Yes, under Article 3 we have this power. Which basically means Union Cabinet got together. Union Cabinet discussed Jammu and Kashmir reorganization bill the morning of August 5, 2019. Union Cabinet cleared this bill but asked the President of India, dear President, please give us the permission so that we can introduce this bill in the parliament and we can seek parliamentary approval for this bill. President said, but for that I have to send this bill to the legislative assembly of that state, which is going to be affected by these changes, which in this case is Jammu and Kashmir Legislative Assembly. But there is no Jammu and Kashmir Legislative Assembly that has been dissolved. So when Jammu and Kashmir Legislative Assembly has been dissolved, who acts as the Legislative Assembly for Jammu and Kashmir? The Parliament of India. So instead of sending this bill to the Legislative Assembly of that state, I am sending it to the Parliament. So basically, Parliament on August 5, Rajya Sabha, one important detail. This bill under Article 3, it can be introduced in either Lok Sabha or Rajya Sabha. That means that's the choice of the government, whether they want to introduce this bill first in Lok Sabha and then in Rajya Sabha, or first in Rajya Sabha and then in Lok Sabha. In the case of Jammu and Kashmir, the bill was introduced in Rajya Sabha. Why? Maybe the government wanted to surprise the opposition because the government was not in a majority in Rajya Sabha. The government wanted to surprise the opposition so that they don't come together, so that immediately this Jammu and Kashmir reorganization bill is passed in the Rajya Sabha, and then once it is sent to Lok Sabha, we have the brute majority in Lok Sabha and we can get this bill passed. That was the intention of the government, to surprise the opposition, to take the opposition by surprise. And ultimately, this bill was introduced in Rajya Sabha. In Rajya Sabha, there was a discussion for a few hours, and Rajya Sabha passed this Jammu and Kashmir reorganization bill. And then this bill was sent to Lok Sabha. On August 6, 2019, Lok Sabha also passed this bill. This bill was passed by both houses of the Indian Parliament. Simple majority was required. And ultimately, this bill entered into force on October 31, 2019. Why? To coincide with the birth anniversary of Sardar Vallabhbhai Patel, the Iron Man of India, the man of unity. And ultimately, Jammu and Kashmir was bifurcated into union territories. Union territory of Jammu and Kashmir, the union territory of Ladakh. But then this Jammu and Kashmir reorganization bill was also criticized. Criticized on many fronts. One such front was Article 370. How? If Article 370 was there, because in the morning of August 5, the president issued an order and said Article 370 is no longer operational. So basically, the protection of Article 370 is no longer there. What is this Article 370? I told you I'm going to tell you in the chapter of Jammu and Kashmir. You can go through that chapter of Jammu and Kashmir right now and see what Article 370 is all about. But very briefly here, if there was Article 370, Indian Parliament did not have the power to reorganize Jammu and Kashmir without the concurrence of the Legislative Assembly of Jammu and Kashmir. For other states, only consultation was required. With respect to Andhra Pradesh, Madhya Pradesh, Bihar, Uttar Pradesh, only consultation with these states was sufficient. But so far as Jammu and Kashmir was concerned, the status accorded to Jammu and Kashmir under Article 370, Parliament did not have the power to reorganize the state of Jammu and Kashmir without the permission, without the concurrence of the Legislative Assembly of Jammu and Kashmir. But on August 5, 2019, there was no Article 370. It was dead. It was not operational. It was de-operationalized. So ultimately, this protection of Article 370 was not there. So Jammu and Kashmir became just like any other Indian state. So just like any other Indian state where there is no concurrence required, the parliament enacted Jammu and Kashmir Reorganization Bill, and ultimately Jammu and Kashmir was bifurcated into two union territories. That's number one. Number two, some people argued that when we look at president's rule, under president's rule, yes, parliament becomes the legislative assembly of that state. If a state, Jammu and Kashmir, is placed under president's rule, who becomes the legislature of the state which is under president's rule? Parliament. So all the powers, all the laws that are to be made for the state, this law will be made by parliament. That means this law will be made for the state which is under president's rule. By whom? By the parliament. And all the powers that are available, all the powers that are there for the Legislative Assembly of Jammu and Kashmir will be transferred to that of the parliament. But that's only for temporary period. That's only for temporary period of 6 months, 8 months, 10 months, 1 year, 2 year, maximum 3 years. Because 3 years is the maximum validity of a president's rule. You cannot continue with the president's rule for more than 3 years in any state, because that's the constitutional limit. There is a maximum validity of a president's rule, and that maximum validity of a president's rule is 3 years. That means president's rule by its very nature is temporary. Since there is a breakdown of constitutional machinery, since no political party is in a position to form the government, since we can't hold elections right now, that is why let's have president's rule. So president's rule by nature is temporary. Can, in a president's rule, parliament make changes for that state which are of permanent character? Can, in a president's rule, state be downgraded to that of a union territory? That goes against the very concept of federalism. Supreme Court has said federalism is part of the basic structure of Indian Constitution, and no act of parliament, not even a constitutional amendment act, can violate the basic structure of Indian Constitution. Critics say Jammu and Kashmir Reorganization Act, it violates the principle of federalism. Why? Because this state, which was placed under temporary president's rule, because president rule by its nature is temporary, can during this temporary phase parliament make changes to that state which are of permanent character? If that is the case, if the answer is yes, then tomorrow our entire constitution can be converted into a unitary constitution. How? It takes few steps to convert a federal constitution into a unitary constitution. What are these steps? For example, West Bengal or Tamil Nadu or Odisha or Punjab, for example. If the central government is not happy with the governments of these 4 states, what the central government can do? Impose president's rule. When president's rule is imposed, ultimately what will happen? This state is placed under the control of the parliament, and based on the recommendation of the parliament, what it does, it downgrades the entire state and converts the entire state into that of a union territory. That means the principle of federalism is getting violated. But there are those who say, how is this principle of federalism getting violated? Because in any case, the states don't have a say. If, for example, you're saying impose president's rule, then downgrade the state to that of a union territory, this can happen even without imposing president's rule. How? Union cabinet clears a bill. West Bengal, the reorganization bill, it is sent to the president that please give us the permission. We want to convert the state of West Bengal into union territory of West Bengal. President will say, no, I want to consult the Legislative Assembly of West Bengal. Mamata Banerjee is furious. She says, I am rejecting this bill. The Legislative Assembly of West Bengal is rejecting this bill in toto. Even then the president will say, it doesn't matter. I'm giving the permission to the government. Please table this bill in the parliament. Get West Bengal reorganization bill passed and ultimately downgrade West Bengal to that of a union territory. So how is principle of federalism getting violated? But there are others who say, yes, Parliament does have the power to merge two or more states to create a state, to bifurcate a state to create two states, to trifurcate a state to create three states. Yes, that's the power available with the Parliament. Yes, a part of that state can be taken out and made into a union territory. But for God's sake, how can you convert the entire state into that of a union territory? That means, yes, a part of that state can be converted into a union territory. But the residuary state, the residue which is left, the remaining part of that state which is left, it must exist as a state. You cannot downgrade the entire state to that of a union territory, because federalism is part of the constitution, basic structure of Indian constitution. What is basically a union territory? There is no distribution of powers. There is no dual government. Two important ingredients of a federal constitution. One, there should be dual government. Two, there should be distribution of powers. Union territory, by its very nature, is under the control of the union, is under the control of the center. That means union territory concept, it violates federalism. Can the entire state be downgraded to that of a union territory? Is it possible? That's why we have a petition pending in the Supreme Court, because there is a constitutional challenge. There are various petitions challenging the constitutional validity of Jammu and Kashmir Reorganization Act of 2019. They say it is unconstitutional because it violates federalism, which is part of the basic structure of Indian constitution. Others also say this. They say when the state is under president's rule, as I told you, this president's rule by nature is temporary. And how can Parliament make permanent changes to a state which is under a temporary rule? That's something you can't do. But let's look at president's rule by its nature. In a president's rule, what happens? President issues a proclamation. I am issuing a proclamation, I'm the President of India, that the state of Jammu and Kashmir is under president's rule. What I do, I say all the powers that are with the state, that are with the executive, will remain with me. That means all the powers of chief minister, all the powers of the ministers, all the powers of anybody in that state will be vested with me because I am the president. I cannot vest two powers with myself. One power is the power of the High Court, because there is separation of powers. I cannot take up the judiciary powers. I cannot take up the judicial powers. So when president issues a proclamation that there is a president's rule in the state of Jammu and Kashmir, I as a president, I can take up executive power because I am the executive head of the state. But I cannot take up judicial powers. And at the same time, I am giving legislative powers to the parliament. That means in this presidential proclamation, I'm saying Parliament becomes the legislature, the legislative assembly for the state of Jammu and Kashmir. And all the powers that are available with the legislative assembly of Jammu and Kashmir will be transferred to that of the Parliament. That means Jammu and Kashmir legislative assembly, it has law-making power. All these law-making powers are transferred to that of the Parliament. But what happens in Article 3? Please understand this carefully. Under Article 3, when this bill is cleared by the cabinet, union cabinet, it is sent to the president. President sends this bill to the legislature for what? Asking the views of that legislative assembly. Critics say that this view is different from law, which means yes, in a president's rule, law-making is the power which is given to the parliament. But how can parliament take over the right of a legislative assembly to give its view? That is something which president's rule does not snatch from a legislative assembly. This right to give views to the president. That is why on this ground also it has been challenged in the Supreme Court. Let's wait and watch. Let's see what Supreme Court has to rule on this matter. But this completes our Article 3 of the Constitution of India. Just to recap, Article 1, India, that is Bharat, shall be a union of states. Article 1, Clause 2, the names of the states and territories thereof shall be specified where? In the first schedule. Article 1, Clause 3, the territory of India shall consist of. Either we can have states, or we can have union territories, or we can have acquired territories. And one example of an acquired territory that I gave you, the French settlement of Pondicherry, now Puducherry. Article 2, Parliament may by law. What Parliament can do, it can enact a law. And through this law, it can admit into union or establish new states on such terms and condition as it thinks fit, as Parliament thinks fit. And one beautiful example for that is the Sikkim. And then Article 3, which is a centralizing tendency of Indian federalism. Parliament can make sweeping changes, reorganize the state, and that is the power which is available only to the Parliament. The states only have a consultative role. But whatever views are given by the state legislative assemblies, those are not binding on the president. And ultimately, the states can be reorganized. That's Article 3 for you. Now I'm going to tell you something tricky. And what is that tricky part? Let's say, for example, Andhra Pradesh Reorganization Act was passed. Before this act was passed, Andhra Pradesh had 18 MPs in Rajya Sabha. Where is it mentioned? It is mentioned in Schedule 4 of the Constitution of India. What is Schedule 4? Schedule 4 talks about the representation of states in Rajya Sabha. For example, in Rajya Sabha, we will have 31 MPs from Uttar Pradesh. In Rajya Sabha, we will have 18 MPs from Andhra Pradesh, for example. Clear? So this is 2014 data. There are 18 MPs from Andhra Pradesh in Rajya Sabha. But when this Andhra Pradesh Reorganization Act was passed, according to this act, there will be 11 MPs in Rajya Sabha from Andhra Pradesh. There will be 7 MPs in Rajya Sabha from Telangana. Where is it to be mentioned? In Schedule 4. Any change that you make in the Constitution, for that, what do you need? You need to amend the Constitution. How Constitution is amended? A bill under Article 368 is to be passed, because Article 368 talks about the manner in which the Constitution can be amended. For that, what is the majority required? Special majority. Please understand this carefully. What am I trying to say? There is Schedule 4. When there is Schedule 4, it talks about the representation of states in Rajya Sabha. Let's say, for example, in 2014, before Andhra Pradesh was bifurcated, there were 18 MPs to Rajya Sabha from Andhra Pradesh. After the act was passed, after the state was bifurcated, Andhra Pradesh Reorganization Act said, out of these 18, 11 will be allocated to Andhra Pradesh, 7 will be allocated to the new state which has been carved out, and that new state is Telangana. But it is to be mentioned somewhere. The representation of states in Rajya Sabha is to be mentioned somewhere. Where is it to be mentioned? In Schedule 4. That means if you make any changes to the Constitution, what are you trying to do? You're amending the Constitution. But we have discussed, when we discuss the type of the majority, in amending the Constitution, you require special majority. But a bill under Article 3 requires simple majority. Andhra Pradesh Reorganization Bill required simple majority. Jammu and Kashmir Reorganization Bill required simple majority. That means bills under Article 3 require simple majority. How can a bill which is passed through simple majority make changes to the Constitution, amend the Constitution, because Constitution can only be amended by special majority? Give me the answer. Not just that. Schedule 1. In 2019, let's say on August 4, 2019, Schedule 1 of the Constitution of India talked about only 7 union territories. But now, 31st October 2019, the same Schedule 1 also talks about Jammu and Kashmir, Ladakh as 9 union territories, part of the 9 union territories. But Jammu and Kashmir Reorganization Bill, it only required simple majority. How can a bill which requires simple majority make changes to the Constitution, because constitutional amendment requires special majority? Please explain. How is that possible? That is possible because an exception is provided by Article 4. What Article 4 says? If there is a law which has been passed by the Parliament under Article 2 or under Article 3, for example, a new state is to be admitted into India, or a new state is to be established under Article 2. Whenever you do this, whenever Parliament does this, there will be changes in Schedule 1 and Schedule 4. Whenever a bill is to be passed under Article 3, for example, Jammu and Kashmir is to be downgraded to that of 2 union territories, we have to mention that these names will be mentioned under first schedule of the Constitution. We have to ensure that previously there were 4 MPs to Rajya Sabha from Jammu and Kashmir, but now There will be no MP from Ladakh Union Territory in Rajya Sabha, but there will be 4 MPs from Jammu and Kashmir Union Territory in Rajya Sabha. This is something that we have to mention. Where is it to be mentioned? In Schedule 4. That is why Article 4 says, whenever Parliament makes a law, under Article 2 or 3, there will be changes. Where these changes will be? In Schedule 1 and 4. But these changes are coincidental. These changes are supplemental. These changes are consequential. And they won't be deemed as amendment to the Constitution. Which primarily means, when Jammu and Kashmir Reorganization Bill, when Andhra Pradesh Reorganization Bill is passed, it is making changes to Schedule 1 and Schedule 4. Don't treat this bill as constitutional amendment bill, because their primary focus is on reorganization of the state. Their focus is not on amending the Constitution. Even if Constitution is amended, but it is supplemental, it is incidental, it is a consequential matter. The issue is Andhra Pradesh is to be reorganized, but the consequence is Schedule 1 and Schedule 4 is also getting changed. So Article 4 provides an exception. In these cases, Constitution is making an exception under Article 4. When Parliament is making a law under Article 2 and Article 3, there will be changes in Schedule 1 and Schedule 4, but don't treat these bills as constitutional amendment bills. That means you can make changes to Schedule 1 and Schedule 4 by simple majority. Special majority is not required. That's Article 4 of the Constitution of India. Now let's look at something else. On 26 January 1950, when the Constitution of India was enacted, when the Constitution of India entered into force, we had 4 different categories of territories in India. We had Part A, Part B, Part C, Part D. Part A, for example, we had Bombay and Madras. Basically, those provinces which during the British rule were under the Governor General. If you would have read modern history, you would know that we had Governor General. We had princely states. We had some provinces which were under the control of chief commissioners. That is why in 1950, we had 4 different kinds of territories. Part A, for example, Bombay, Madras, basically which during the British rule were under the control of the Governor General. Similarly, Part B, princely states, Jammu and Kashmir, Hyderabad, Mysore. Part C, which during the British rule were under the control of chief commissioner, for example, Delhi, Coorg. And in Part D, we had Andaman and Nicobar Islands. Then the question was, let's reorganize this country. Let's delete this Part A, B, C, D differentiation, and let's reorganize this country into states or states and union territories. For that, a commission was set up. The year was 1948, June 1948 to be precise. It was called the Dhar Commission, headed by S.K. Dhar. It was asked, please tell us, how can we reorganize this country? Dhar Commission said, there should be only one criteria in reorganizing this country: administrative convenience, not on linguistic lines. Which means then there was a popular demand that we should have states on the basis of language. We should reorganize this country along the linguistic lines. For example, one state for Telugu speaking population, one state for Marathi speaking population. That means we should reorganize this country on the basis of linguism. That means we should reorganize this country along the linguistic lines. But Dhar Commission said no, not linguistic lines, but only on the basis of administrative convenience. Few months later, December 1948, another committee was set up, JVP Committee. JVP is an acronym which stands for Jawaharlal Nehru, Sardar Vallabhbhai Patel, and Pattabhi Sitaramaya. Pattabhi Sitaramaya, you would read him in modern history. He once contested the election of the President of Indian National Congress against Subhash Chandra Bose, and ultimately he lost the election. But when you lose to a fighter, when you lose to a stalwart, automatically your share price also goes up. And that is how people started remembering Pattabhi Sitaramaya. But ultimately, this committee also said the same thing as was said by the Dhar Commission. It said administrative convenience, not linguistic lines. That means we should not be reorganizing this country along the lines of language. Why? The policy makers at that time, they had an apprehension, they had a fear that we have just come out of colonialism and we have to work really hard to keep this country united. And if we are going to reorganize this country along the lines of language, maybe people will start respecting their language, their state more, and not the union and not the country as a whole. And ultimately, it may be a very important ground for secession as well. Maybe some state might want to come out of the Union of India. So, to prevent the secessionist feelings from developing, that is why this committee said not on the basis of language, we should reorganize this country along the lines of administrative convenience. And then came Poti Sriramalu, who was also known as Amar Jeevi, immortal being. He was a Gandhian. He went on fast unto death. Why? Because he wanted a separate state for all the Telugu speaking population. If there are Telugu speaking population in Madras, in Mysore, in other parts of the country, all these Telugu speaking population areas should be merged together to create a united state of Andhra for Telugu speaking population. His demand was rejected. He went on fast unto death and ultimately he died. There was a series of protests. Protests broke out in large parts of Telugu speaking population and ultimately the government had to succumb to the pressure. And then the government decided to create the first linguistic state in India, Andhra. October 1953, Andhra was carved out as the first state to be carved out along the lines of language. But then people thought, policymakers thought, that we can't have a hit and trial method. We can't have a situation where people protest in a particular area, then we will succumb to these protests and ultimately create a new state. There has to be a rationale. There has to be a policy on the basis of which we should reorganize this country. And that is how, a couple of months later, December 1953, a 3-member commission was set up. The first States Reorganization Commission, headed by Mr. Fazal Ali, H.N. Kunzru, and K.M. Panikkar. This commission was asked, please tell us how can we reorganize this country into various states. And States Reorganization Commission submitted its report in September 1955. Some of their recommendations were accepted, some of their recommendations were not accepted, and ultimately, in 1956, States Reorganization Act was passed. And when this act was passed, Part A, Part B, Part C, Part D, this differentiation was done away with. The entire country was reorganized into 14 states and 6 union territories. That means if you look at 1950, Part A, B, C, D, then various commissions were set up. Tell us, how can we reorganize this country? Commission said, administrative convenience should be your moot point. Administrative convenience should be the sole criteria in reorganizing the country. Protesters said, no, language should be respected. And ultimately, States Reorganization Commission was set up. And what States Reorganization Commission did, it said, yes, language can be a criteria in creating a state. But it rejected one language, one state formula. What am I trying to say? That States Reorganization Commission, which submitted its report in September 1955, it gave number of recommendations. Some of these recommendations were accepted, some were not accepted. That we don't have to remember. That's irrelevant from the examination point of view. But what States Reorganization Commission recommended, it said, yes, we can have a look at language as one of the determining factors in creating a state. We should have no problem in creating states in the name of language. We should not have any such problem. But we are going to reject, and we reject in toto, this formula called one language, one state, which basically means that there should be one state for Marathi speaking population, no. There should be one state for Tamil speaking population, no. Why? If you look at this recommendation, when we say States Reorganization Commission did recommend that language can be a criteria to create a state, but it rejected this formula called one language, one state. Why? Because by that logic, almost the entire North India would have been one state. Because if you look at Haryana to some extent, if you look at Uttar Pradesh, if you look at Uttarakhand, if you look at Rajasthan, if you look at Himachal Pradesh, they're Hindi speaking areas. Then, by that logic, almost the entire North India would have been one state. But it would have been an administrative nightmare to administer such a vast state. That is why it said we can have 3 states where Marathi speaking population are a majority. That means, yes, on the grounds of language, we can create a state or we should create a state, but we should not have one language, one state formula, because inherent within the States Reorganization Commission was this recommendation that administrative convenience is the key. On the basis of administrative convenience, we should be reorganizing this country. And that is how in 1956, when States Reorganization Commission was set up, Part A, B, C, D differentiation was done away with. We had 14 states and 6 union territories. After 1956, we saw another round of reorganization. For example, Goa became a state. For example, Gujarat was carved out from Bombay, Maharashtra, Gujarat. Then we saw another round of reorganization when Chhattisgarh, Uttarakhand, and Jharkhand were carved out. Then the bifurcation of Andhra Pradesh. Then the bifurcation of Jammu and Kashmir. And now there are people who are demanding second states reorganization commission. They're saying, look at the demands from different sections of our society, from different areas of our country. If you look at Uttar Pradesh, for example, there is a demand that Uttar Pradesh be trifurcated. Uttar Pradesh is such a big state, it is difficult to manage such a big state. So Harit Pradesh and Bundelkhand should be carved out from Uttar Pradesh. Similarly, Maru Pradesh should be carved out from Rajasthan. Coorg in Karnataka should become a separate state or a union territory. Vidarbh in Maharashtra, which is where you see a large number of farmer suicides. Bodoland in Assam. We saw Bodo Accord last year, but even then, there are still people who want a separate state called Bodoland in Assam. Gorkhaland in West Bengal. That means if there are so many demands from different sections of the society, different parts of our country, it is better that we replicate the formula that we used in 1953 when States Reorganization Commission was set up. So now is the time to appoint a second States Reorganization Commission and look at all these demands from different sections of the society. That is what you need to know about Articles 1 to 4 of the Constitution of India, Part 1 of the Constitution of India, Union and its territory. This chapter is over.